In today's video, I'm tackling a hot topic: Trump's recent executive order targeting the Equal Employment Opportunity Commission, also known as the EEOC, and why it may seriously impact your rights at work. So stick around, we have a lot to cover. Before I get into Trump's EEOC order and its impact on workers, we first need to talk about what the EEOC is and why it matters for workers. The EEOC is the federal agency that investigates workplace discrimination claims under federal laws like Title VII of the Civil Rights Act. Title VII prohibits discrimination based on race, color, religion, sex, and national origin. And a critical point, especially for this video, is that the Supreme Court's decision in 2020 in Bostock versus Clayton County held that discrimination because of someone's sexual orientation or gender identity is also discrimination because of sex. In other words, LGBTQ+ workers are protected under Title VII. This is Supreme Court precedent, which is binding on the EEOC, meaning that the EEOC cannot just ignore it. Now, why is the EEOC so important? Because under federal law, if you believe you've been discriminated against, you can't just file a lawsuit in federal court right away. Typically, you must file a charge of discrimination with the EEOC first. They investigate, gather evidence, maybe try to settle with your employer, and if they decide not to pursue the matter themselves, they issue what's known as a right to sue letter, which then allows you to file your case in federal court. Now, the EEOC filing process isn't always necessary to file a claim, so I'll briefly touch on why that is first. Do workers always have to file their charge with the EEOC before they can bring their claim in court? Well, no, not always. You see, many states have their own anti-discrimination laws and their own state agencies that can investigate these claims. Some states even allow you to skip the administrative process altogether and file your lawsuit in state court immediately. For instance, in Washington state, where I'm licensed to practice, you can go straight to court under the state law and skip the agency route if you choose. But in other states, especially those with fewer local protections, you may need to file with the EEOC to enforce your federal rights. If you skip that step, your federal lawsuit can get dismissed. So if you live in a state that has stronger workplace protections, you might never interact with the EEOC. If you're somewhere else, you could absolutely have to rely on the EEOC to handle your discrimination claim. And even if you aren't required to follow the EEOC process in your state, the EEOC can still be very helpful for investigating your claim. I'll explain a little bit more about that later on in this video. But before I do that, let's talk about Trump's executive order and what is happening at the EEOC right now. Now, let's talk about the big news: Trump's executive order number 14168, which is titled Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. I'm not going to quote the whole order because it's 9 pages long, but I'll link to the order in the description of this video and give you a brief overview. The order seeks to enforce a gender binary approach to interpreting Title VII and appears to walk back the protections for LGBTQ+ workers who don't fit into that binary. Plus, Trump appointed a new EEOC chair named Andrea Lucas, who has publicly stated that she wants to roll back these protections, calling the protections a gender identity agenda. Under the new EEOC leadership, the Commission has already released a statement outlining its plans to roll back these protections, stating that the current laws protecting gender identity and LGBTQ+ status were fundamentally flawed because they ignored what Andrea Lucas referred to as biological reality. I'll link to this press release in the description. But here's the critical conflict. The Supreme Court in Bostock versus Clayton County held that discrimination against LGBTQ+ people is a form of sex discrimination under Title VII. That means that legally, the EEOC cannot just roll back these protections under the current legal framework because Title VII's protections apply to these workers. So the EEOC will likely not outright refuse to accept these claims based on LGBTQ+ status unless it wants to directly defy the Supreme Court. But what they probably will do, and what we're already starting to see, is that instead of outright blocking these claims, the EEOC might instead just immediately give workers a right to sue letter without actually doing a thorough investigation. But what does that mean in practice? Let's get into it. So why does this matter? Why isn't a quick right to sue letter a good thing? Well, the EEOC investigation process can be incredibly valuable for workers for a few important reasons. First, evidence gathering. The EEOC has the power to subpoena documents, interview witnesses, and gather information on a worker's behalf. Most workers can't afford to do that on their own. If the EEOC stops investigating, you lose that resource. Second, employer pressure. When the EEOC investigates, employers tend to sit up straight. They know a finding of discrimination could lead to federal lawsuits or penalties. Without an active investigation, some employers might not take your claims seriously. Third, building a case. If the EEOC finds evidence supporting your claim, that cause finding strengthens your position if you have to go to court. If they never even investigate, you might not get that chance to uncover helpful information before you file your lawsuit. Fourth, finding a lawyer. Without uncovering evidence to support your claim through the EEOC process, it will be much more difficult to find a lawyer to represent you because lawyers who work in this area generally do so on a contingency basis, meaning they only get paid if they win your case. So generally, employment lawyers want to see some evidence supporting your case before they agree to take on that risk. Put simply, if the EEOC decides to just hand out right to sue letters and call it a day, they shift the entire burden of investigation onto you to do what the EEOC previously handled. Now, if you're in a worker-friendly state with robust anti-discrimination laws like Washington State, California, or New York, you can bring your claims under state law and your state agency might still do a fair investigation. But if you're in a state that doesn't have those protections, or where courts heavily favor employers, you may only have your federal Title VII claim to rely on. And that means going through the EEOC's process. If the EEOC won't investigate, you're left in the dark, forced to gather evidence and push the case forward all by yourself. You might be thinking, I'm not LGBTQ+, does this even affect me? And the answer is possibly yes, because the whole point of the EEOC is to enforce all kinds of workplace discrimination laws. If the leadership decides to curtail investigations in areas they deem low priority, they may also reallocate staff and resources elsewhere, possibly leaving other types of discrimination claims hanging. There's also talk of the EEOC focusing more on reverse discrimination claims. These are claims for workers who say diversity initiatives have put them at a disadvantage, for instance. If resources get redirected to those kinds of cases, it might mean less attention to more traditional claims, like racial discrimination or sexual harassment. Keep in mind, these changes don't happen overnight with a flashing red banner on the EEOC website. They often happen quietly in how day-to-day operations are handled. That's why you might start hearing stories from people who filed charges saying the EEOC just gave me a right to sue letter and told me to go away. Now, you might be asking yourself, what about Bostock? Didn't the Supreme Court already decide this in Bostock versus Clayton County? Well, yes, the Supreme Court in Bostock versus Clayton County explicitly said that firing someone for being gay or transgender is firing them because of sex. And that's illegal under Title VII. Therefore, Title VII applies to LGBTQ+ people. The EEOC cannot just override the Supreme Court's interpretation of a federal statute. However, what the EEOC can do is effectively say, we accept your filing, but we're not investing resources into investigating it. Here's your right to sue letter, have a nice day. That probably doesn't violate Bostock on its face because they're not outright refusing to recognize the claim, they're just pushing the case to the federal courts where it costs you time and money to investigate and litigate the claim on your own. And it puts you at a severe disadvantage. Now, it's important to know that this might get challenged legally. Workers and advocacy groups can claim that failing to investigate a claim at all is essentially refusing to enforce the law. But that type of challenge can be tough, and lawsuits against a federal agency can take years to resolve. Meanwhile, real people with real discrimination claims will fall through the cracks. Let's talk about what you can do if you find yourself dealing with this new EEOC environment. Number one, document everything. Keep any emails, texts, write-ups, or performance reviews. These will be critical if the EEOC doesn't investigate on your behalf. Number two, understand your state laws. If your state has a robust anti-discrimination statute, like Washington State, you might be able to bring your claims in state court without going through the EEOC process, so just check the rules or consult with an attorney in your state. Number three, know the right to sue timeline. Normally, the EEOC has 180 days to investigate before you can request a right to sue letter. If they're fast-tracking you, that might mean they're skipping the fact-finding process altogether, so be prepared to gather that evidence yourself or to hire an attorney if possible, and you'll have to do this pretty quickly. Number four, ask questions. If the EEOC calls you to say they're issuing the letter right away, ask why they're not investigating. Get names and titles of who to speak to. Documentation can matter later if there's a legal challenge to the agency's actions. And remember that every situation is different. If you suspect discrimination, speak to a lawyer who understands your state's laws and can guide you on whether you should try to get the EEOC to investigate or just proceed under state law. So what happens next? Well, executive orders can be reversed if courts step in or if a future administration changes course. But for now, we're in a period of uncertainty. If Andrea Lucas and the current EEOC leadership put these policies into practice, the biggest impact will be on low-income and marginalized workers who rely on EEOC investigations for evidence and leverage against their employers. It's possible that over time, lawsuits might challenge these new directives, arguing that they conflict with the Supreme Court's precedent in Bostock. But until then, many people's cases may not get the thorough investigation they deserve. That's especially true in states without strong local protections. If you're lucky enough to live in a state with strong anti-discrimination laws, you still have those rights, so definitely look into your state's process if you need to. But the bottom line is this: if you have to depend on the EEOC for your discrimination claim, there's a chance your investigation will be minimal under this new regime. So, to wrap it all up, Trump's Executive Order 14168 and the new leadership at the EEOC may seriously undermine the investigation process for certain discrimination claims, particularly those involving LGBTQ+ workers, despite the Supreme Court's ruling in Bostock. While they can't legally block these claims altogether, they might issue right-to-sue letters without doing any real digging, which means workers will have to pursue lawsuits on their own dime and time. If you found this video helpful, please hit the like button and subscribe to my channel. I make videos on the laws that protect workers, because the more we hold employers accountable for the wrongdoing, the more we protect other workers. Thanks for watching, and I'll see you next time.